Benissimo, allora con un'ora di ritardo nel tipico stile trentino, direi che possiamo iniziare questa seconda parte dell'ultimo panel. Permettetemi anche a me di ringraziare gli organizzatori, ovviamente mi riferisco agli organizzatori materiali, operativi di questo convegno, e quindi il nostro staff, lo staff dell'Osservatorio Antitrust, i nostri interpreti che stanno facendo un grande sforzo per garantire anche per questa edizione lo standard particolarmente ambizioso che ogni 2 anni ci poniamo per questo convegno. E qui io chiaramente parlo anche a nome del professor Gian Antonio Benacchio. Quando ho pensato a questo panel, quando abbiamo pensato a questo panel, ci siamo posti almeno 3 obiettivi. Essendo l'ultimo panel dell'ultima giornata, dopo 2 giorni particolarmente intensi, ci siamo posti l'obiettivo di rendere il panel il più possibile leggero, il più possibile piacevole, senza però tradire il rigore scientifico e accademico che ha contraddistinto i primi momenti, diciamo, di dibattito. Il secondo obiettivo era quello di stimolare il dibattito tra i membri del panel e tra i partecipanti. E il terzo obiettivo, e credo che sia quello più difficile anche alla luce del ritardo che ormai abbiamo accumulato, è quello di arrivare puntuali alla cena di questa sera. Abbiamo organizzato una cena in Piazza Duomo, abbiamo già differito la cena alle 8:30 anziché alle 8 come originariamente previsto, quindi questo avviso vale proprio per comunicarvi anche questo leggero differimento. E credo che per raggiungere questi obiettivi che ci siamo posti, e spero che anche voi condividiate, abbiamo pensato a una formula piuttosto rapida, una sorta di speed date, come suggeriva Paolo Palmigiano del Competition Law, che si basa su una formula rapida, appunto, di interventi secchi di 10 minuti, one shot, possibilità di raccogliere domande subito dopo ciascun intervento. Mi aspetto che ci siano domande dai partecipanti, visto che ormai siamo ampiamente nelle nuove frontiere dell'antitrust, forse saremo addirittura oltre le frontiere dell'antitrust, secondo alcuni, e parleremo appunto di nuovi mercati, di non mercati, quindi cercheremo veramente di non cadere, però, come appunto ammoniva giustamente il dottor Pezzoli, di non cadere oltre la frontiera. Quindi 10 domande, spero che ci siano domande dal pubblico. Se non ci sono domande chiederei ai panelist di farsele tra di loro, di suggerire almeno qualche commento. In ultima analisi poi interverrò io per fare qualche osservazione, ma veramente in ultima analisi. Io voglio avere un approccio molto minimale per lasciare spazio a voi e ai nostri ospiti. Se tutto procede bene, come spero, dovremmo essere in tempo per raggiungere l'obiettivo 3, che è quello appunto della cena, altrimenti salteremo la cena. Abbiamo già cercato di saltare il pranzo oggi, quindi insomma al limite pagheremo una penale al ristorante, ma spero proprio insomma di no, che riusciremo a essere in tempo anche per questo ambizioso obiettivo. I temi dunque sono molto vari, c'è un unico comune denominatore, come ricordava Roberto Chieppa, che sono le nuove frontiere dell'antitrust. I temi sono di grandissima attualità, e proprio perché l'attualità vede anche Google in questa settimana, proprio nelle principali pagine dei giornali, anche loro su loro malgrado probabilmente, di notizie di cronaca economica, lascerei subito la parola a Miguel Pérez Guerra, che è Senior Competition Counsel di Google per l'Europa, che ci appunto parlerà di a che punto siamo arrivati e che cosa abbiamo imparato dai casi Facebook, WhatsApp e Microsoft Skype. Prego, Miguel.
Thank you. Well, most Spaniards think they have a natural talent to speak Portuguese and Italian, but very few, a very select few, can actually get away with it with some dignity. I'm not one of them, so I beg you to pardon me for resorting to English. I'd like to start by thanking Professor Capagnano and the University of Trento for inviting me over. And I've been tasked to kick off this last session about new frontiers, and I've chosen the latest decisions that we have, Facebook, WhatsApp, and Microsoft Skype, to illustrate what it is, if you like, that we can learn and how to move forward with technology sector and online markets. Before I do that, however, I thought I'd address the obvious elephant in the room, if only for 1 or 2 minutes. As you all know, Commissioner Vestager had an interesting press conference a couple of days ago where she announced that the Commission would be addressing a statement of objections against Google in its 5-year-long search investigation. It is an open case, so you will excuse me if I don't go into too much detail about what the concerns are and what our approach to those will be. There is a public paper, so to speak, that outlines what our defense will look like, and it's available at that web address. So please feel free to give it a look. It includes loads of what I'm sure economists love, which is graphs, showing trends and showing how competitors have fared up. So, as I say, you're more than welcome to go in and have a look, leave your comments, because obviously there is a section for comments in that web page. The second thing that Commissioner Vestager did was announce that the Commission was going to open a formal investigation into Android. Of course, that is in an even more preliminary stage than the search investigation. We will have to wait and see before we can actually comment anything. So, without further ado, so Facebook, WhatsApp. That decision tackled a number of very interesting issues. There's the question about jurisdiction and whether turnover thresholds are the best measure to determine whether a deal must be notified to a competition authority for merger control purposes. There's also market definition issues in that decision. As you all know, in innovative sectors with fast-evolving technology coming into play, it's increasingly difficult to arrive at a decision of what constitutes a market for substitutability purposes and what consumers view as interchangeable. It also raised issues around market shares and how those can or cannot be representative of market power for a given company. It also tackled network effects, or more precisely, how network effects might not play such an important role in innovative markets. And it also addressed the question of big data. So today I'd like to focus on market shares and big data. I'll begin with the latter. And I'll start off by asking, what is big data? Is there such a thing as big data? What turns data, period, into big data? What characterizes a collection of information or its use into what's being coined as big data? What are the dangers of big data, if there are any? How much data do we need, or what kind of information does big data refer to? I mean, I don't pretend to have the answers to these questions. I'm just trying to draw attention upon the fact that there's a lot of talk about big data and how that may impact antitrust. And perhaps the more humbling approach would be to ask ourselves, do we really know what we're talking about? Because what I call there an inconvenient truth about big data is that analyzing statistical information, collecting information about consumers, collecting information about competitors has been something that companies have been doing for a very, very long time. And I believe that if there were a statistician here in the room, they would concur that big data as a concept is something that's been around for the last 10, 15 years, but not much has happened. And we don't seem to ever get to the promised land where big data, where a collection of data will solve all of our problems. Not as consumers and definitely not as companies. Focus groups have been around for more than 15 years. Essentially, it's putting a bunch of people together, asking them what they think about a product, about a service, and extracting conclusions, extrapolating. And that's something that statistics has been involved in for centuries. So the inconvenient truth is that there's nothing new about data that would characterize it as big data. And then the immediate question that follows is, well, regardless of what we think big data might be and what it might do, does it have an influence in antitrust? Is there something that competition law should be concerned with when we allow companies to collect data from their customers, and use it in ways that may not immediately seem obvious. Well, that's a Facebook post that illustrates the problem, the fundamental problem with big data. Everyone seems to know what it is, or fears that their competitors know what it is, but in reality, nobody really knows what they talk about when they speak about big data. Perhaps not the most elegant of analogies, but still pretty effective. As I say, when we speak about big data, when antitrust regulators are jumping up and down saying that data privacy and data collection can be an antitrust issue, what is it that they're concerned about? Out of all the potential inputs and commodities that are out there, data is as close and as liquid to cash as any other input could get. It doesn't run out. In that aspect, it's even better than cash. It cannot be easily monopolized by any given company. When a user, a consumer, shares a piece of information about themselves with a company, it doesn't mean it cannot be reshared again. So when we hear certain politicians saying that maybe data is the new currency, while there might be an interesting ring to that phrase, query whether that actually leads to competition problems. Query whether that could lead to foreclosure. Not yet there. The Commission in the Facebook WhatsApp decision, even though they did ponder during the investigation whether or not to consider privacy and data as a competitive constraint for competitors, they did arrive at the conclusion that competition law was no place to analyze, at least in that particular case, to analyze data privacy and data protection considerations. And at the end of the day, the reason why that is true is because no matter how much data a company accumulates, it doesn't mean it isn't a replicable model by other companies. And therefore, if it is replicable, why would accumulating data end up being a problem for competition purposes? And why would it be able to lead to a prohibition decision eventually, or to a commitments decision? As I say, I don't purport to have all the answers, but I did want to bring this up. One other thing that the Commission said in its Facebook WhatsApp decision was that even if Facebook tried to bank in on the heaps of data that WhatsApp had been collecting from its customers, even in that case, even in that instance, the deterioration of the product could scare customers away. So that in itself was a disciplinary factor for WhatsApp, and that it was unlikely that it would exercise its control over data in such a way that it would harm consumers, only because obviously, when that happens, and we've seen a number of examples where Facebook has changed its privacy settings, the amount of bad press, of bad PR that it generates leads a lot of customers to stop using their products. And as I'll say later on in the market share section, in innovative markets, especially in the online world, where products and services are traded essentially for free, yes, it's a two-sided market, or there's a freemium model, but consumers, us as consumers, can choose which products to use without incurring in a direct payment. Switching costs are nil. So in that environment, the fact that data could be used in the wrong way should not be a competitive concern, because as soon as data is used in a bad way, we've seen examples, real-life examples, of customers switching away from very successful products and choosing to take up different ones, which are also available for free. So that was one key finding of the Facebook WhatsApp decision. Regarding market shares, as I just said, online business models tend to rely on a freemium, either a freemium or a two-sided way to monetize their products, meaning the customer very rarely actually pays a price to use a collection of apps or of services. It's either paying for the use of extended features, of premium features, or another person financing that activity through advertising, obviously. In such a context, how can we seriously define market shares? This is a difficulty that the Commission faced, both in the Facebook WhatsApp case and in the Microsoft Skype decision. Obviously, defining market shares necessarily leads you to have to define a market, and usually market definition relies on price considerations. If you take the SNP test, for instance, first thing that all of us have been taught in market definition is look at substitutability. And the way you do that, the way that you gauge whether a consumer will switch away to another product, the most immediate way to do that is, well, ask the customer, the consumer of that good, what would they do if prices increase? Well, there's no price here, and there cannot be a price. And the simple reason for that is that if one single company decided to start charging a price, I don't think it would be successful. There's a plethora of competitors out there that are prepared to sacrifice short-term profits. And not only that, there's a plethora of companies out there that have managed to figure out ways to monetize their investments, to monetize their products and services in ways where the direct consumer doesn't have to pay for those products and services. So trying to move away from that system at this stage is not really feasible. And you can see that in the newspaper editing sector, where online newspapers have been having not a very good time over the past few decades trying to decide what to do with their business model. Not only the actual papers, but the online versions as well. You've seen news outlets starting to charge for their content and then moving away from that business plan because they simply cannot keep up with what other competitors are able to do. And that's one of the interesting things about online businesses, that there's always the pattern, that the maturity cycle that a majority of these businesses are in allows for immediate reaction by competitors, and the ease of access to customers, to end users, is so obvious that mavericks and new entrants are just around the corner. It doesn't take too much, it doesn't take high levels of investment to come up with the new innovative feature that will win the market over. So when the Commission decided to look at what they called reach, which is basically active end users in the last month in the context of the Facebook WhatsApp decision, why did they choose that metric? Well, obviously, in the case of Facebook and WhatsApp, especially WhatsApp, the measure of how much of turnover, so a market share based on total turnover versus market turnover in the market for communication apps, was a metric that was not significant enough of WhatsApp's position in the market. The reason is quite obvious. There were 4 countries where WhatsApp was charging its users a yearly fee, and at the time of publication of the decision, that list went down to 2. So essentially, it still is giving out its product away for free. And therefore, looking at turnover was not the best of indicators of market power, or market position, rather. What other things could they have looked at? There aren't that many. But the thing here is, and the point I'm trying to make by pointing the spotlight at usage shares, which is what the Commission called reach, is that usage shares of free products and services are not a good proxy at all of market power, or of market position for that matter. As I said earlier, the fact that we're dealing with free-to-use products, switching costs being zero, both in terms of financials and in terms of time to accustom oneself to that product change, it all ends up in usage shares being highly volatile. And what better proof than the 1996 versus 1998 ABA antitrust section winter and fall meetings. These were the keynote speeches in those. You see how Alta Vista, if anyone here in the room remembers what that was the leading search engine back in 96. 2 years later, and by leading I mean really dominant, 2 years later, that position was successfully taken over by Yahoo. In each of the speeches, the main message was, well, clearly, this is here to stay for a long time. Well, apparently not. And the reason being, it's free products that we're talking about, and competition literally is one click away. I know it sounds cliche, but when you access the internet, you have many ways of reaching a website, a search engine in this case, and searching for it is just one of those. You can simply type the URL in the URL box. So the fact that an adoption rate of a product or a service that's free to use is high can be as a result of usefulness of the product as much as it is of trend, which also serves to explain why MySpace was the leading social network, 8 years ago? 9 years ago. So 9 years ago, no one knew what Facebook was. It was MySpace that dominated the social network landscape. If anyone remembers what MySpace is, congratulations, because I don't. I never had a profile there. What does this all come to prove? Do we really want to make decisions based on a parameter that doesn't really show how much a company, product, or service occupies of the total pie that's available to users? Because in fast-growing and innovative markets where products are free to use, where switching costs are zero, where adoption rates depend as much as on usefulness, on trendiness, on what my friends use and what my family uses, how can we assess how important a product, a service, a company, at the end of the day, is in that market by referring to those usage rates? In my opinion, it's not very useful. And that's not just me, it's also my employer who thinks it's not very useful, obviously. So yes, I'll be more than glad to take any questions and to expand on any of these topics or any others that you may reasonably have, and also for the chair to.
Great. Let's open the floor to the audience. So if there is any question in Italian or in English, please go ahead.
It's in Italian. I have to pick up my
headphones. So please, before your question, identify yourself for the recording system. Thank you.
Okay. Miguel Ferro from the University of Lisbon. I'm surprised to not hear a clear position on whether free markets exist at all. You're challenging, the way you calculate market shares in markets where a product is offered for free. But is there such a thing as a relevant market for a free product?
Well, obviously, companies do compete. I'm not challenging that. And companies have offerings. The thing here is, what side of the market is most relevant to assess market power? And I don't think the free side of the market is as relevant as the paying side of the market if you want to base your analysis on market shares. So that's what I'm trying to draw attention on. If the framework is, let's use market shares, usage shares, you name it, percentages over total usage of a product, the free side of the market isn't the best place to apply that kind of thinking to.
Let's wait the audience. Another question up there? I will scale your minutes from your speech.
My name is Edoardo Marangoni. I'm a student from the University of Trento. And I don't expect you to agree with me, but I really don't think that free, like your definition of free, does it embody also data sharing? Because this is really not free for me. Like, if I know that using a device or using a certain software, I am sharing my data with that company, I don't think I'm using it for free. Yeah, that's my point. But I'm waiting for your answer on this comment. Thank you.
I mean, that's why I say that it's a very powerful soundbite. This whole thing that data is the new currency. What's free television? What's free loyalty programs? My whole argument is this new? Really? When you join a supermarket loyalty program, don't you think that every time you scan your card, your purchases are being studied? Your purchasing patterns, if not your specific purchases against your name? And again, big data. Really? What's new about big data that wasn't there when statistical models were developed centuries ago? As long as you have a sample that's representative enough of the entire universe that you're trying to analyze, your findings are 20 years ago as good as they could be right now with more immediate access to data. And even if data was a currency, even if we equated data to cash, obviously, yes, a company that has a lot of cash has a competitive advantage. But again, where's the foreclosure? Where's the antitrust element that leads there to be a concern? Because having a lot of money, which gives you an advantage, does not mean that other companies cannot be successful as well. So change money for data. Accumulating a lot of data does not mean that other companies cannot have access to a lot of data as well, even the same data.
Thank you, Miguel. Another question over there. Two more. It's not an auction. This, the other one, and then Paolo Parmigiano, so we can speak to the other speakers.
Elisabeth König from Dollar Procuratorius in Austria. I hear, or you said, or you showed that the difficulty with these concepts, which were developed in kind of traditional markets, the market share and the usage share, is not useful for these new markets that are developed. And I hear you said you do not have solutions, but I'm sure you have a proposition. And I didn't hear this in your presentation. So maybe you could add to that.
Well, yes. If you want to analyze dominance, for example, which is quite a trend when someone speaks about Google lately, let's go back to the basics. What's dominance? What did the Court of Justice say in Hoffman-LaRoche? And I agree that it's difficult, but then again, it might be lazy of some people to simply resort to market shares as the only way of analyzing market dominance or market power. So, if the definition of dominance is being able to act in the market, to put out your products and behave independently of competitors, suppliers, and ultimately consumers, then that's what we should head towards. And since markets where products are being traded for free shows that market shares aren't the best way of analyzing market power, then we should work towards going back to analyzing whether with specific economic evidence a company is able to behave independently from its competitors, from its suppliers, and ultimately from its consumers. Again, nowhere in any textbook definition of dominance will you see that market shares are what determine dominance. They're a proxy, a good one for most industries, but for others it may not be the best proxy. It may not even be a good proxy at all. And when the Commission and the Court have given thresholds, they always say that over a certain percentage, over 60% is a good indicator of dominance, but they never say that there is definitely dominance and that it does not allow a company to prove otherwise.
Thank you, Miguel. The last question from the audience, over there, or not? No? Okay. So, Paolo Palmigiano, please.
I wanted to go back to the market definition of free apps. If you look at the Commission decision, there's actually quite an interesting section that deals with free apps versus normal communication, SMS and telephone. And you will see substitutability one way but not the other way. I think it's still evolving. I had one comment and one question. The first one was, I think what you said about switching, etc., it's valid in the context of this case. WhatsApp, I can easily move to Skype or any other thing. But let's take Facebook. If you use it and you have 10 years of data there, will you switch if somebody else comes along? When your history, it's all there. That's the first point. The second point, you were talking, this was an interesting case because it was a merger filing that was done voluntarily by Facebook. And if you applied the turnover test, it would not have been captured by the EU merger regulation. So one question I have, I know in the US the test is different, is the value of the transaction.
Yep.
And this was a big, big value. I think 90 million or billion?
Billion.
20. So clearly, if you had a value test, this would be captured. Mm-hmm. In the online world, should we move to a different merger test?
I'll take your first question first. Interestingly, I did not include a couple of screenshots, which did include Facebook as well as Google. Both platforms allow for immediate download of all your data. Everything that's stored on Facebook, the Facebook stores of you, and everything that you decide to share with Google, there's an option to download your entire history. Or not, just delete it, do whatever you want with it. So, yes, I see what you're trying to get at, which is, isn't that a switching cost? Or a barrier for others to enter the market successfully, because people will have a tendency not to change because they've invested so many years of their time and they already know how Facebook works and all their data is there and all their friends are there. But then again, if data protection regulations give users the tools already to avoid company abuse of resulting from owning data, if data privacy regulations already force companies to implement solutions like these ones, where the data owner is the real owner of the data and can decide at all times how much, whether or not their data is still being stored in the company's servers. When that's in place, query whether we should add an extra layer and have antitrust enforcers also considering this this whole data protection aspect for merger control purposes or for dominance purposes. As to turnover threshold, that's a tricky one. It's well, you know, we've spoken about this and in the ICLA contributions to the merger control review process. I think we need stability of some kind. We need certainty, and I don't think the UK system is the entire best, where filings are voluntary, but then again, you might be required by the authority to actually do a filing even after you've closed. Market share thresholds, there's a double barrel problem there, because if we're talking about new markets, there's the obvious problem of having market shares in with products that are new, and if they're free, there's a double problem with it. So I'm not sure going towards the Spanish and the Portuguese model, where there's a market share threshold, is the best solution either. The size of transaction test, which is applied in the US, kind of combines the best of both worlds, because it gives you a measure. If a company is prepared to pay that much money for another company, it gives you a measure of how important that target company is, regardless of how many users, active users, it had in the last 30 days. And that's something that the Commission considered in the Facebook WhatsApp deal. Look, if we had a different test, a different set of thresholds, we wouldn't have had to go through the upwards referral mechanism. But at the end of the day, the system did work. There were filings necessary in 3 countries, and the notifying party decided to ask itself for a voluntary referral. So I don't think we're in a position still yet where you could throw your hands in the air and say the system isn't working. I don't think we're there yet.
Thank you very much, Miguel, for your insight.
Thank
your
you.
speech, wonderful. Thank you very much. We move very quickly to Álvaro Ramos. He's going to speak about antitrust and IP exhaustion. Álvaro is competition legal counsel of Cisco in Brussels. So please, Álvaro, go ahead.
Thank you very much. I hope I can do a job as good as Miguel has done. It's very hard to argue with a straight face that Google is not dominant. I think Miguel has done a very persuasive job. I will, let me just start by saying that I am speaking on my own behalf and the usual caveat, but to move very quickly to IP exhaustion, what I want you to learn today is relatively simple. So I want you to understand what's an IP right, why there is a tension between IP and competition law, which is defined mostly by the exhaustion doctrine, and why, and this is the critical point, this is so important for companies. So those are the 3 elements, and I have about 10 minutes to talk about this, so I hope in this speed dating I can seduce you about this topic, which is incredibly relevant for companies. So whether you're external counsel or an in-house counsel or you're a practitioner, I think you're going to come to deal with these issues in the future. So hopefully this helps you to understand the framework. Now, an IP right, the essence of an IP right is relatively simple. It's a legal monopoly. It gives you the right to exclude others. Or in a more technical fashion, an IP right gives me the exclusive right to be the first one that sells that product, incorporating the IP into the market. So if I take this pen, for example, I'll be exclusively entitled to sell it for the first time. Now, once I have sold it, my rights are exhausted. That's why we call it the exhaustion doctrine. This is very relevant because this determines a critical aspect of an IP right, which is the value of the IP right. So for those of you that work at companies, you're probably familiar with this. This determines the value of your IP because it depends on how you can monetize your IP. So how is this relevant for antitrust? Once you have sold the market, anyone can then take it and resell it. Those are the people that often compete against you in the secondary market. Sometimes if it's a used product, it's a slightly different market, but sometimes it's not. So the Court of Justice was asked back in the days of Dutch gramophone about this very question, about should we have national exhaustion, should we have international exhaustion. The case, you may remember the facts of the case, it relates to a company called Dutch Gramophone that was selling records in France and in Germany. At the time, Germany had national exhaustion, which meant that Dutch Gramophone was exclusively entitled to sell those records in Germany. They had sold those records in France. Somebody took them and was trying to resell them in Germany. The court was asked, is this something that national exhaustion, is this something that is compatible with the treaty? And the court said, no, it's not. This is a barrier of trade between countries, and you should stop it. You should not have it. You should let people buy anywhere in the EU and resell it anywhere in the EU. Now, what would be the EA? So now that you understand, so there is the two scorpions in a bottle scenario where you have IP and antitrust. Then let's talk a little bit about how is this relevant for companies. And we had a case that, I don't know if you heard about the Oracle Usoft case, which is, I see a lot of people noting, it is a case that set the limit on software. So just to give you the factual background of the case, if Oracle was selling databases, so software protected product, copyright protected product, software, but was only granting a license. If you follow the same approach that you do in the US, a license does not give you, only gives you the right to use. It does not give you the right to resell that to others. The Court of Justice, contrary to this interpretation, said now, you have licensed, that's the same thing, you have licensed your software, to me that's the same thing as a sale, and your rights are exhausted. This is a significant change. I don't know if you understand what it means for companies, but it basically means that companies had attributed value to a copyright, to a software, and they realized that value was a lot less because the court has all of a sudden regulated a fundamental IP aspect, and this regulation did not come after years of analysis and sometimes that can be long and painful, but it was all of a sudden in a decision, it came with that basically saying, no, once you've licensed your software, that's it, you've lost it. So, it sets again the limits between IP and competition. Once you have licensed your software, all bets are off. Anyone can take that software, resell it, relicense it, whatever you want to call it, and compete against you. So how is this? So hopefully that leads to the next point about how is this relevant for companies. And in the IT world, for example, a lot of companies in the IT world lose more sales against their own products than they lose against their competitors. This is people, and this is hard to understand for a lot of people, but you do compete about people that sell second-hand products. Sometimes they get those products outside of the European Union and they resell them here. So this is a major loss of business for a lot of companies. Now, the law is very, very clear. You buy any gadget in China, not counterfeit, I'm not talking about that, genuine product in China, you resell it in Europe, you're violating the IP rights of the trademark owner. So, is there a way for companies, and this is where I guess the practical advice of the presentation comes in, is there a way for companies to stop that? And until now, companies were simply unable to stop that because there were too many people doing too many things, and there was simply no efficient way of attacking resellers that were selling products in violation of their IP rights. Now, the law has changed in many countries. Notably, the UK is perhaps the most advanced country when it comes to discovery. And it sets one principle that is critical for hardware makers, for example. It basically says, if I learn that you have been selling my products in violation of my IP rights, not only you're liable for that product, but there is a very simple way of going to court and ask for pre-action disclosure. What it means is I can open your books for the last 6 years. For every product you have sold that you cannot demonstrate, and this is quite important, you cannot demonstrate that you have bought within the EA, then you owe me. Because exhaustion is a defense that has to be proven by that person that alleges exhaustion. In other words, if you claim you've bought that product in the European Union, then you have to be able to prove it. If you can't, then you're liable. Now, 6 years. Imagine that every time you speed on a highway, you're not just responsible for that speeding ticket that you can get, but for all the speeding you've done in the last 6 years. You'll think twice before you press on the accelerator, wouldn't you? Thank you very much.
Great. Alvaro, any question from the audience? Not about speed limits, please.
They are exhausted.
Okay, so let's switch to Paolo Palmigiano. He is going to speak about vertical restraints and or in the online world. Please, Paolo, go ahead.
Stay here. Perfect. There's no doubt that what we're discussing now online is on top of the agenda of every competition authority. You're fully aware, clearly, of the recent market inquiry launched by the Commission, which clearly, if you are in-house in the sphere or as a lawyer, will give you a lot of work, with an outcome still to be seen, 2 years of hard work. But it will be an interesting one, because the Commissioner said clearly she was going to look at obstacles by company in the online world. And I asked her the question, what about IP right, copyrights? Because those are obstacles, as you know, for selling goods across member states. And she said, obviously, every company will be able to make any comment they want and point to the finger at anything which is an obstacle. So we'll see what happens. And it's also interesting that just 2 weeks ago, the DOJ had issued the first criminal case versus an online commerce. And it's quite a peculiar one, because these were companies that were fixing prices on Amazon Marketplace through an algorithm, an assistant that was allowing them automatically to fix price at any point in time. So you can see there's lots of work going on, lots of things. But what I'm going to discuss very quickly is vertical restraints, and therefore that brings me to the vertical block exemption and three main classes of restriction where there's been some attention, and in some cases a lot of attention by authorities. Exclusivity, which is there's a lot of discussion in the block exemption. Price parity clauses, which is a novel form of restraints, which has been, as you know, Booking.com and Amazon.com. And then thirdly, the exclusive selected distribution, which has given rise in the last 5 years, I would say, to a huge amount of cases in France and Germany, sometimes conflicting among themselves and even conflicting with EU law. So we'll see what happens there. I think online is a good thing for consumers. You can quickly search, you can quickly get comparison of prices, you can even shop in other countries, and you can even buy things you wouldn't buy in shops, brick and mortar shops. But there are threats. Clearly, if you become dominant, you can foreclose new entrants. But also, there's a lot of increased transparency that might allow some collusion between players. And you've seen what has happened, what I was just mentioning in the US. But it is quite obvious that the Commission, since the beginning, thought online commerce was a good thing. The aim has been for years to achieve a single market. Online world, you might have it. So they became quite concerned about anything that might restrict online commerce. And that's why when in 2010 the vertical block exemption was renewed, there was an entire new section on online, which is very novel. It's nowhere else to my knowledge. So clearly the Commission decided, I need to regulate this market because I need to be sure there are no restrictions there. And what is also interesting is that the way the Commission approaches vertical restraints in the online world is the same, the way in which they approach offline. Basically because there are shops which sell both online and offline. So clearly creating different rules would have created some problems. But there are some differences. And let's move to, for example, distribution agreements. Let's go to distribution. I think the last case the Commission did was Peugeot in 2002, if I'm not mistaken. There's been no enforcement whatsoever. And it's interesting that actually it's the section in the vertical block exemption which is the most prescriptive. Just to recap a bit, if you remember, exclusive distribution is possible in Europe. You can appoint an exclusive distributor, France, Italy, Germany. And you can say to that distributor, you will only sell in your country. If you're a distributor in Italy, you can only sell in Italy. But one thing the Commission has always been very keen is allowing what they call passive sales. If I'm based in France and I want to buy from the distributor in Italy, and I go directly to that distributor, the distributor must be allowed to sell to me. So there's this distinction which is fundamental in the block exemption about active and passive. That is moved into the online world, but in a slightly different way, because there are certainly differences. I think the main principle is internet sales are passive, so they must always be allowed. So that's the first principle, I think, that the Commission puts in the block exemption. And therefore they start thinking, what is a restriction of passive sales in the internet world? And if you go through the block exemption, you have lots of specific examples. For example, if a customer is located in another country and I prevent access to him, that's a hardcore restriction. The same is, I'm buying through the website, I'm in Italy, I'm buying on the website of the distributor in Germany. I enter my credit card detail. As you know, by the credit card number, the company will know where I'm based. And at that point, the sale is stopped. That's illegal as well. And the same is charging different prices for online and offline unless there is an objective justification. There's a couple of things that can be restricted. As we said before, active can be restricted. In the online world, that means, for example, saying to a distributor, you cannot actively go and seek customers in another country, for example, creating a website which is specifically addressed to them or sending them emails. On the other hand, you might have a website in all languages as long as it's not specifically targeted to customers outside your territory. So a lot of very prescriptive rules which clearly make possibly sometimes the advice more difficult, but at least we have an idea where things are. Then we move to a novel area, which, as you know, almost every competition authority has looked at, price parity clause. If you're interested in this, there's a fantastic article by the UFT, I think about 6 or 7 years ago, where the whole debate started. That was before Booking.com, before all this case. And they go through a lot of different price parity clause. And they start from the most simple. The paper is written by economists, so they see some harm even in conduct which should not be illegal under the law. But they have one case, for example, they call it a cross-sellers agreement. In the UK, you go into a shop, and for example, at the airport Dixon's, you want to buy something, and they'll say they'll match any price that Amazon or other shops offer you. The same supermarkets. You go to a supermarket, they'll give you money back if you find the same product cheaper in another supermarket. That's great for consumer, because that brings the price down. That's what economists say, because what happens is you start having a sort of a soft point where nobody has any interest to deviate from the same price. So at the end, you tend to be at the same price. But the problem for the economists and for the law is there's no agreement. So clearly, yes, there might be harm, but difficult to persecute. Differently in the case of what we call a cross-platform agreements, the Booking.com of this world. Basically, you have an agreement between the platform and the seller promising that the final price on that platform will be no higher than sales through the other channels. And I'll tell you what it means by talking about Amazon and Booking.com. Let's take Amazon. It has something called Amazon Marketplace. I can put and sell things on Amazon, so can businesses. But if you're a business, what it means is if you put your product on sale on Amazon, you cannot sell it at less than that price, either directly, so I can't, or through other channels. Now, clearly, that's an issue. Why it is an issue? Because let's imagine I put something on Amazon for £10. Amazon charges me 10% commission. So at the end of the sale, I'll get £9. So I could easily sell through my channel at £9.50 and make actually more money because the commission is not included. But the agreement with Amazon stopped me from doing that. And what is the concern? The concern by competition authority was clearly leads to no ability from the seller to fix its own price, but also imagine there's a new platform wanting to undercut Amazon. There's no way they will be able to do it because if I want to put my product on them, it will still have to be £10. Quite similar Booking.com. In a sense, Booking.com had agreement with certain hotels that said, you put it on me, on my platform, that's the price at which you'll have to sell through your own direct website, Hilton, for example, or through any other platform, Expedia or others. And again, Same concern about foreclosing of rivals, etc., etc. And clearly, both, as you know, they're being handled with settlements, both Booking.com and Amazon in various member states. If you take Booking.com, what they've done, for example, they've abandoned the parity clause, so the hotel is now free to sell at the price they want to other platforms. But they can still have an agreement between Booking.com and themselves, saying that the price on which they sell on their website will not be lower. Now, when these cases started, I was a bit confused, because it seemed to me that's an HC agreement. The price is set up by the hotel. Where's the issue here? But then you start thinking, actually, it's a funny type of agency. It is true that it's still the principal that sets the price. But Booking.com has a huge amount of costs. You know, they invest heavily. At that time, they used to say, we are the cheapest, come to us. So there's a huge investment by the agent. But also what is odd is, usually all the restrictions come from the principal on the agent. Here you have the thing the other way around. It's the agent that asks the principal to have a restriction. So I can see why an authority might want to say this is slightly different from an agency agreement. And now I'll move very quickly to the third point of my speech, which was selected distribution. Again, very easy. You know, company can restrict the number of distributors they have, not just by territory, but also by the way, by the number. They can require criteria by which, possibly, mostly because it's high luxury good, and there were some ways in which it is sold. And clearly, because they're high value products, companies believe, I don't want it to be sold on eBay. There's a brand recognition which is valuable. If you start selling at a discount in a discount shop, Costco in the US, clearly the value of my brand is reduced. But the EU, again, very, very strict, very strongly negative reaction. An outright ban on internet sales within selected distribution is an infringement of 1011, unless it's justified by objective reasons. So very, very strict. That brings me to think, well, companies should be free to choose the way they sell goods. Imagine I produce toothpaste. Online, offline, I can easily sell it, decide to sell it through supermarket, pharmacy, or not selling at all, or selling. Why is it so different online that I'm actually forced to sell when I don't want? So what has happened is, I think lots of attention from, as I was saying, Germany and France. But first, just a couple of principles that apply to sales online in the selected distribution. And again, those are in the vertical block exemption. First of all, if the manufacturer sets criteria for the sale of its own good, can have different criteria, whether it's online or offline. They don't need to be identical. They need to achieve the same result. And also, the fact that a manufacturer allows a distributor to sell online, the fact that a distributor must be allowed to sell online, doesn't mean that the manufacturer must allow online-only distributors to become part of the network. And the third point, which is actually an interesting one for the one I'll say later, it's paragraph 54, the block exemption. It is legitimate for suppliers to require customers not to visit the distributor's website carrying the name of logo or a third-party platform. And I'll tell you why that is important in a minute. So, France, lots of cases. The most famous one, which you all know, is Pierre Fabre. Mm-hmm. The requirement was cosmetic products, and the requirement was on the distributor, you need to have a pharmacist present to sell. Now, clearly, if you're online, there's no pharmacist, you can't sell. As you know, the case went to DCJ. This is a 101 issue. Therefore, you have to stop. The more because actually there's no need to have a pharmacist for selling those products. Very similar in another case, which is Royal Canin. Royal Canin sells food for dogs. And they have developed, that's an interesting one, they have developed dietary food for dogs, which had to be sold at the presence of a veterinary. Again, as you can see, applying Pierre Fabre, the conseil say no. And similar cases, Festina for watches, Bang Olufsen in France, that clarify what a distributor can do. But let's move to Germany. Germany has been possibly the most active country in this area. And you have cases like Cybervision, contact lenses, Cyber is the biggest seller in contact lenses in Germany, and it was prohibiting its resellers to sell online. It was requiring a prescription. Again, the Bundeskartellamt says, well, you can get a prescription by email. You don't need to stop all sales online because of this. But companies are thinking of novel ways to put restriction. Garmin, the producer of sat-navs, they were rewarding retailers that were selling a recommended retail price. But if you were selling below recommended retail price online, then you would get less. So clearly, again, the Bundeskartellamt deemed that to be a restriction. But I would say the most interesting cases are the ones Adidas, the shoes, and Sennheiser, the earphones. Because the restriction that those companies had imposed was that their products could not be sold on eBay and Amazon Marketplace. What is interesting is there, and if you remember, paragraph 54 of the block exemption says you can block access or use of third-party platforms. What happened there? The court says, that's the German court, the court says, no, this is a hardcore restriction, not justified by inefficiencies, and in any case, paragraph 54 in the block exemption has been, or is rendered obsolete by Pierre Fabre. So all of a sudden you have a national court that deviates quite radically from what the Commission has done. And that causes a lot of issues, because clearly if you're setting a distribution network across Europe, you tend to go for the lowest common denominator. So Germany has now become the common denominator you apply in a scenario like this. So it will be interesting if, because of the review of the online sector, I know the Commission is already aware there's an issue where you have member states which have gone slightly differently from the Commission itself. So let's see what happens in this space. Thank you.
Thank you. Thank you very much, Paolo Palmigiano, for this very clear and quick overview of what's happening in the online world. Is there any question from the audience about this issue? One from Marianna Andreangeli, please.
Yes, I would just like to invite any consideration from either Paolo Palmigiano or from Ramos about another set of cases also concerning French courts on e-commerce. I'm thinking about the cases concerning trademarks and the sale of samples. So I'm thinking about L'Oreal and the cases concerning perfumes that, whose samples are sold on the internet. And the European Court of Justice seemed to take quite a wide view of what constitutes the essence of an intellectual property right, especially in respect to a trademark. Seems to be suggesting that trademark is not just right to exclude the usage of trademark, the usage without authorization and, for the purpose of controlling reputation, but trademark fulfills also other functions, for instance, advertising and investment and so on. And I was just wondering whether you had any thoughts about how this novel, in inverted commas today now, way of marketing these products has had any impact that in turn has encouraged the Court of Justice to take such a wide view. Thank you.
Thank you, Oriana. Very straight reply.
No. I have to confess, trademark is not my area. So I was hoping that my colleague had a better understanding. But
It was an or, it wasn't an and, so don't worry about it.
So I don't think it changes a lot. That's my short answer. And let me give you maybe 1 more minute explanation. I think it should, but it doesn't. And the reason is, I think when you own a trademark, you have to have all the freedom in the world to use it anywhere you want to restrict anyone you want to. The Garmin case, I think you've mentioned the Garmin case. Now, does everyone in the room know what Garmin is? Yeah. It's a personal navigation device maker. Their market share is not through the roof, and there are more navigation devices now than we've ever had in history. Tell me how we are negatively affected by this. On the other hand, don't they know better how to use their trademark? Now, here is certain things that I get the Commission practice. For example, when I say, well, do not use my trademark when you're reselling my product. That's an unnecessary restriction, because if I cannot say that I am reselling an iPhone just to, for lack of a better example, then I need to use their trademark iPhone in order to resell it. So that's a restriction that type of use of IP rights certainly sounds anti-competitive. But in any other case, applying a per se test to something that is so fundamentally important like a trademark, I think is something that is devoid of, is unconnected from reality. That's, sorry for the longer answer, I just thought.
Thank you very much. So we can switch to...
Northern
no,
case.
you're not allowed, Paolo.
I'm allowed 30 seconds. I mean, all the cases you've seen were 101-1. You've heard earlier on about Car Bancaire. I think one of the issues will be, will national competition authorities still continue applying so strictly 101-1, or will it have an impact? To be seen.
Okay, so great. So we give the floor to Sasha De Clesis. He's an attorney in Rome. He will speak about compliance program. This is another very interesting frontier of antitrust law. So Sasha, please go ahead. I think Sasha will speak in Italian.
Grazie. Allora, io innanzitutto voglio ringraziare Michele e l'Università di Trento per l'invito e questa splendida opportunità di essere in questa bellissima università. Chiedo scusa ai miei co-panelist di effettuare l'intervento in italiano. In realtà, essendo il penultimo della giornata, immaginavo di trovare un uditorio molto stanco. Essendo il mio tema molto meno interessante di quello trattato da chi mi ha preceduto, poteva essere effettivamente un colpo di grazia che non meritavate. Però ho avuto rassicurazioni da Miguel, ovviamente da tutti gli altri, che comprendono molto bene l'italiano, quindi spero di non darvi troppo pena per questo. Io mi occuperò, in più cercherò di mantenere un po' la vostra attenzione, soprattutto dei più giovani, con la semplicità dei concetti. Anche il mio vuole essere un intervento molto molto semplice. In particolare, per finire, cercherò di stare nei limiti di tempo concessi. Parleremo delle strategie di antitrust compliance. In particolare toccherei brevemente l'origine del problema, cioè quali sono gli orientamenti contrapposti in tema di quali sono stati gli orientamenti contrapposti in tema di efficacia degli antitrust compliance program nel dibattito internazionale. Quindi molto brevemente che rilevanza viene data a questi programmi di compliance da parte delle autorità antitrust europee e oltreoceano, e quindi descriverò brevemente quali sono i contenuti di questi programmi. Molto rapidamente, innanzitutto in che cosa consiste un antitrust compliance program? Sono sostanzialmente delle modalità organizzative che si dà a un'azienda finalizzate a monitorare che le attività svolte dall'azienda e dai singoli dipendenti non infrangano il diritto della concorrenza. Ora, perché un'azienda, per quale motivo un'azienda si dota di questi programmi che richiedono, come vedremo, procedure, processi e spendita di tempo e di persone? Principalmente per prevenire la commissione di illeciti antitrust e quindi evitare le conseguenze sia economiche in sede di sanzione da parte dell'autorità antitrust sia reputazionali che ne discendono, per agevolare in secondo luogo la scoperta di eventuali condotte anticompetitive, ad esempio per poi utilizzarle nell'ambito dei programmi di leniency, e in terzo luogo per una ragione educativa, e cioè per rendere consapevole il management e tutto il personale dell'importanza della normativa antitrust, perché effettivamente, come diceva stamattina l'avvocato Creus, effettivamente viene visto il mondo antitrust spesso come una stregoneria, non viene compreso perché un certo comportamento sarebbe illegale. Quindi queste sono le tre principali. C'è una quarta ragione per cui un'azienda si dota di un programma di compliance più opportunistica, e cioè sperabilmente per poter usufruire di benefici in caso venga scoperta ad aver infranto le norme antitrust. Molto rapidamente il dibattito si è svolto principalmente sulla tesi del professor Wouter-Wils, che è stata ribattuta da vari avvocati, tra cui Damien Girardin. La tesi di Wils perché è così importante? Innanzitutto perché è un professore, ma anche un importante esponente del servizio giuridico della Commissione europea, quindi quello che è il suo pensiero in realtà si è riflesso in parte nella posizione della Commissione europea al riguardo. Cosa ha fatto sostanzialmente? Qual è stato il ragionamento? Ha messo sulla bilancia quelli che sono gli effetti che ha riconosciuto essere gli effetti positivi dell'adozione di un programma di compliance antitrust da parte di una azienda, quindi riconoscendo che possono essere utili a portare alla conoscibilità da parte dell'autorità di concorrenza di comportamenti vietati, possono effettivamente portare a termine le infrazioni e possono effettivamente prevenire le infrazioni. Tra gli effetti negativi però ha messo da un lato quelli che ha chiamato effetti perversi di apprendimento, cioè che il personale, una volta istruito su quelli che sono i comportamenti vietati, come vengono condotte le ispezioni, eccetera, eccetera, non diventi altro che super esperto nell'evitare che vengano trovate le prove delle violazioni antitrust e continui regolarmente a svolgere attività anticoncorrenziali. E poi un altro argomento ancora più insinuante, e cioè che questo continuo monitoraggio delle proprie attività da parte delle aziende potrebbe portare a una periodica distruzione delle prove delle infrazioni antitrust. Quindi sostanzialmente il professor Wils conclude dicendo che non c'è un'evidenza empirica per cui gli effetti positivi prevalgano su quelli negativi, in più applica questi effetti a 4 modelli di aziende, da quella più pura, quindi con un CFO assolutamente che non entrerebbe mai in accordi anticoncorrenziali, non permetterebbe mai a nessuno del suo staff, del suo personale di farlo, fino al caso estremo, quindi invece all'azienda guidata da un cartellista incallito che anzi si diverte a fare cartelli, dirigerli e non farsi scoprire, e anche 2 modelli intermedi, e arriva a concludere che l'adozione di un antitrust compliance program non è condizione sufficiente per ottenere la vera compliance, che sarebbe appunto l'assenza di infrazioni, che per avere una reale compliance può essere utile un programma, lo chiamerò d'ora in avanti semplicemente un programma, ma ciò che è importante è la modulazione degli incentivi che vengono fissati per il management, perché sostanzialmente si sostiene anche in presenza di un ottimo antitrust compliance program, se in azienda l'area che si respira è che ciò che conta sono i risultati economici, di fatto tutti i manager saranno orientati a evitare di magari farsi scoprire dal compliance officer, ma continueranno a svolgere attività di cartello. Un altro elemento fondamentale è che ci sono comportamenti esemplari delle personalità chiave in azienda, quindi come l'imprenditore di qui sopra, e quindi la cultura aziendale. Tutto ciò per concludere che l'adozione di appunto antitrust compliance program non merita l'immunità in sede di sanzioni né una riduzione delle sanzioni, e che è un po' la posizione che viene sostanzialmente ripresa anche da un documento della Commissione che, anche se saluta con favore l'adozione di programmi di compliance, di fatto spiega che non se ne ricaverà molto su un piano pratico per le aziende in tema di quantificazione della sanzione. Ovviamente è stato replicato, prima da Girardin, ad esempio, sul fatto che andrebbero premiate le aziende che hanno investito in compliance rispetto a quelle che non le hanno fatto. Anche questo a mio avviso è un argomento opinabile, nel senso che magari non perché un'azienda può permettersi di investire in compliance merita un trattamento migliore da chi semplicemente non se l'è potuto permettere. Dal mio punto di vista io credo che dell'intervento di Wils è molto positivo l'aver individuato in effetti le variabili ulteriori che portano alla vera compliance diverse dalla semplice adozione di un programma, mentre a mio avviso il limite è non aver immaginato un programma di compliance che sia così efficace da poter includere anche quelle altre variabili che effettivamente rilevano al fine di un'effettiva compliance e che sono menzionate dallo stesso Wils. Prima di passare, vediamo che differentemente dalla Commissione altre autorità hanno invece ammesso una riduzione della sanzione, per prima l'OFT inglese e l'autorità francese e l'autorità canadese, e recentemente l'autorità italiana con un approccio a mio avviso molto innovativo, cioè con le recenti linee guida in tema di quantificazione delle sanzioni, pur in un contesto di generale aumento del livello delle sanzioni prevedibili per le imprese, ha ammesso la possibilità che l'adozione di un programma di compliance antitrust sia ritenuta una circostanza attenuante che possa portare a una riduzione della sanzione fino al 15% dell'importo di base. Naturalmente ha posto due condizioni, proprio perché, forse anche per far proprie appunto queste considerazioni che erano state espresse, e quindi in primo luogo che questo allineamento del programma, ci sia un allineamento alle best practice europee e nazionali. Ora magari abbiamo l'opportunità anche di vedere quali sono queste best practice. Di sicuro si sta muovendo molto il mondo dell'impresa per creare delle best practice, ci sono voci che anche l'autorità se ne potrebbe occupare con delle vere e proprie linee guida, e poi la dimostrazione di avere effettivamente di esserci appunto un concreto impegno per seguire queste best practice. Oltre a questo, e secondo me la parte più interessante, indica quali sono gli elementi qualificanti che danno effettività al programma di compliance rispetto alla mera adozione, e fa riferimento proprio a un pieno coinvolgimento del management, all'identificazione di un soggetto responsabile del programma, che effettivamente è probabilmente il punto più importante. Espressamente l'autorità si rifà a un documento dell'autorità canadese che incentra su questa figura dell'Antitrust Compliance Officer molte funzioni, l'adottare un risk assessment legato sia al tipo di mercato in cui è attiva l'attività, sia un'individuazione delle persone all'interno dell'azienda che sono più in grado sono più a rischio, diciamo, di comportamenti anticoncorrenziali, prevedere gli incentivi di cui parlava anche Vils per il rispetto del programma e disincentivi per il rispetto dello stesso. Infine l'attività di training, e qui siamo nel tema ancora della cultura aziendale di cui si parlava prima, e infine molto importanti i sistemi di monitoraggio e di auditing. Si diceva, l'autorità canadese si è rifatta a questo documento dell'autorità canadese che incentra sull'Antitrust Compliance Officer una grande importanza, perché in due battute, poi magari se ci sono domande ci ritorniamo, perché sostanzialmente ha una grande autonomia dai manager, è nominato esclusivamente dal board, riporta esclusivamente al board, può essere licenziato solamente alle condizioni predeterminate in sede di sua assunzione, può ricevere segnalazioni interne anonime, ha poteri investigativi propri. Sostanzialmente si crea quel meccanismo di contrasto di interessi all'interno dell'azienda tra chi voglia perseguire un disegno anticoncorrenziale, secondo lui per l'interesse dell'azienda o anche contro l'interesse dell'azienda, sempre perché la vuole magari lasciare un regalino, perché succede anche questo in alcuni casi che abbiamo visto, e infine prevedendo anche meccanismi disciplinari. Quindi questo è diciamo, quello che sta facendo l'autorità. Cosa stanno facendo le imprese? Le imprese, ricordiamoci, almeno le imprese italiane, oltre a questo tema dell'antitrust compliance, assolutamente importante, soprattutto in alcuni settori davvero fondamentale, sono già le prese con dei loro modelli organizzativi, cioè quelli della 231 sulla responsabilità amministrativa delle imprese, e le recenti norme anticorruzione che richiedono anche lì l'adozione di modelli organizzativi, questo limitatamente alle imprese che svolgono gare pubbliche, di modelli organizzativi in modo da non incappare nei nuovi diciamo pregnanti poteri dell'autorità anticorruzione che è stata recentemente istituita. Quindi cosa fanno le aziende? In questo contesto si sono organizzate in particolare in sede di International Chamber of Commerce, e noi abbiamo il piacere di poter dire che hanno partecipato anche avvocati italiani, tra cui Ciro che è qui presente, alla redazione di questo toolkit, quindi di un grande volume molto dettagliato che per il momento si limita a fornire delle opzioni alle aziende su quali possono essere, perché si parte sempre dal presupposto che non c'è un programma che va bene per tutte le aziende. Ovviamente esistono settori dove esistono determinati rischi molto alti e settori dove i rischi sono assolutamente minimi. Io ora non entro nel dettaglio perché non voglio che Michele mi blocchi. Inizio a strappare i fogli. Infatti, però scorrendo queste queste ipotesi si vede che sono esattamente gli stessi punti dell'autorità canadese, con forse qui in più una cosa che riguarda più noi avvocati, cioè la possibilità di un'hotline esterna con un consulente esterno, quindi l'Antitrust Compliance Officer ha anche l'opportunità di farsi consigliare senza dover chiedere il permesso al board o al management di chiedere consiglio a un avvocato antitrust se quello che gli è stato riferito che avviene in azienda è legale o meno, che è un punto che anche questo si inserisce in quella dinamica di contrasto di interessi molto bene. Io non so quanto tempo mi è rimasto.
Se vuoi fare giusto qualche considerazione finale, così aspettiamo, o no? O volevi... Quante slide?
Ma non è moltissimo.
Dai, 2 minuti.
Dai, 2 minuti. Io proprio per partecipare allo spirito di questo tavolo di lanciare sassi nello stagno rispetto a nuove frontiere, visto che finora non ho detto nulla di nuovo, di non conosciuto, se non agli addetti ai lavori, mi chiedo il tema oggi qual è, se sia opportuno che l'autorità garante adotti delle linee guida in tema di compliance. Io non ho un'opinione forte sul fatto che debba adottare delle linee guida o meno, sicuramente ho un'opinione sul fatto che se le dovesse adottare potrebbe utilizzare questo strumento per appunto pretendere una compliance efficace. E io qui ho inserito poche slide su un punto specifico, e cioè pensando a quelli che sono gli altri obiettivi di enforcement, e cioè a considerazioni molto generali. Primo, che moltissimi cartelli non vengono scoperti fondamentalmente, cioè c'è una debolezza dell'enforcement soprattutto nelle ipotesi dei cartelli più importanti. E secondo, che anche quando vengono scoperti molto spesso la società capogruppo rispetto all'impresa che ha posto in essere la violazione riesce a scampare a questo... stavo bloccando il... riesce a scampare alla sanzione. Ho notato insomma che proprio scandagliando questa giurisprudenza in tema di responsabilità della controllante per i fatti della controllata si potrebbe immaginare la compliance di gruppo, la pretesa di una compliance di gruppo come un potentissimo strumento per andare a prendere quei soggetti, soprattutto i più grandi, che sfuggono oggi in qualche modo alla sanzione. Molto brevemente, noi sappiamo che la controllante viene addebitato alla controllante la persona antitrust della controllata se le due insieme costituiscono un'unica entità autonoma. Perché questo avvenga ci deve essere la capacità di esercitare un'influenza determinante e che questa venga esercitata in concreto. Nella pratica noi sappiamo che in scenari di controllo totalitario, cioè quando c'è un controllo al 100%, c'è una presunzione che la controllante sappia ciò che fa la controllata. In realtà questa presunzione conosce importanti eccezioni. Mi viene in mente quella dell'investitore puramente finanziario, cioè del soggetto che detiene azioni in un'impresa allo solo scopo di trarne i profitti e quindi si astiene da ogni coinvolgimento nella gestione delle attività, che è stato escluso, possa, proprio perché come nell'ipotesi di Will si limita a fissare degli obiettivi di budget ma non vuole sapere cosa succede sotto, eppure è stato escluso, ed è il caso dei grandi fondi di investimento internazionali che sfuggono alla responsabilità da capogruppo. O ancora...
Secondo.
Ok. Sì, o appunto, questo non so perché si sta montando così. Questo era un caso in cui ancora una volta la capogruppo riusciva a sfuggire proprio dimostrando la mancanza sostanzialmente di un legame organizzativo con la controllata. Quindi io quello che, questa è l'ultima slide e ho concluso, la mia opinione è che in realtà forse più che guardare quanto è utile per le aziende, dovremmo pensare quanto è utile per le autorità antitrust che le aziende adottino forti programmi di compliance. A mio avviso un'adozione massiva di antitrust compliance program effettive, quindi che creino quel contrasto di interessi, sarebbe un meccanismo moltiplicatore della scoperta di condotte anticoncorrenziali, perché avremmo i board inondati di casi che forse è il caso di portare come leniency application alle autorità antitrust. Avremo una significativa agevolazione dell'attività investigativa e istruttoria, perché tutta quell'attività di reportistica che viene prevista sarebbe probabilmente i primi documenti su cui l'autorità garante con l'ausilio della Guardia di Finanza, salvi poi tutti i temi di privacy e difesa se qui invece ci divertiremmo, salterebbero. E in ultima ipotesi gli incentivi a una compliance di gruppo potrebbe avere un impatto proprio sul tema della responsabilità della capogruppo e sulla maggiore difficoltà per questa di dimostrare l'indipendenza economica delle sue controllate per non essere soggetta al meccanismo sanzionatorio.
Grazie mille all'avvocato De Clesis. Prego. Diamo subito la parola al segretario generale Roberto Chieppi.
Penso di avere a disposizione solo una domanda. Io ero incerto se fare una domanda all'avvocato Ecclesi o all'uditorio. All'uditorio avrei chiesto se, parlando in italiano, è riuscito in questa impresa improbabile di non dare il colpo di grazia, però dalla presenza penso che Sasha sia riuscito. Sulle programmi di compliance sono stati oggetto di una discussione ampia all'interno delle autorità e nell'ambito di linee guida che forse conducono a un inasprimento delle sanzioni, anziché direi che conducono a un inasprimento delle sanzioni, abbiamo deciso di inserire questa attenuante, consapevoli di tutto il dibattito dei pro e contro, questa attenuante sia per incentivare condotte virtuose, sia indirettamente ed emerso per incentivare i programmi di leniency che, come sappiamo, nell'ordinamento italiano non sono così tanti sviluppati. I presupposti, come è stato detto, abbiamo le best practice, gli elementi indicati li abbiamo tratti dall'autorità canadese, e quelli mirano a evitare, che forse quella è anche una criticità nello scritto di Wills, la cosiddetta cosmetic compliance, cioè quella che sia solo di forma ma che nulla abbia di sostanza. Io penso che sia sicuramente prematuro pensare a linee guida sulle compliance. Diamo tempo ad attuare le linee guida sulle sanzioni. C'è stata una prima applicazione in cui l'attenuante richiesta dalle imprese non è stata concessa. Vengo alla domanda. Sasha ha detto la compliance serve per agevolare la scoperta. Allora, nel dibattito sui vari tipologie dei programmi di compliance, anche con riferimento al tempo in cui questi sono adottati dalle imprese, volevo sapere qual è il suo parere sui cosiddetti programmi di compliance ante factum, cioè può essere, perché questo sulle posizioni anche di quelle autorità come quella francese hanno una posizione particolare su questo, noi non abbiamo preso una posizione espressa nelle linee guida. Può essere considerato un attenuante anche il programma di compliance che in concreto avrebbe potuto o dovuto portare alla leniency nei casi in cui ovviamente in cui è possibile il leniency program, e in concreto non abbia condotto alla leniency, o questo è un elemento da valutare caso per caso?
In linea di massima io sono dell'idea che vada valutato caso per caso, perché effettivamente caso per caso e mercato per mercato è davvero difficile capire cosa rilevi o meno. Detto questo, io credo che ogni misura vada fatta tenendo conto che nelle aziende c'è un conflitto, cioè c'è l'aspetto, diciamo, cosmetico, ma c'è anche quindi fare tutto ciò che serve, quindi anche l'antefactum, però diciamo tenerlo in considerazione nella valutazione caso per caso, per rispondere alla domanda, tenendo conto appunto che ogni misura che può in ogni caso inasprire questo conflitto, quindi costringere l'azienda a non entrare in accordi anticoncorrenziali, a mio avviso va agevolata.
Prego.
Cerco pure di dire una cosa, lo dico in inglese perché in italiano non... You talk about conflict of interest. There's a fundamental point that it may not be obvious for a lot of people, that there is a fundamental conflict of interest between a salesperson that sits in a smoking room and fixes prices with their rivals and a company. And let me explain this so that people understand, and that's what a good compliance program should fix. If I'm a salesperson and my commission depends on me infringing the law, and I'm put in that evil position where I have to choose between putting my children through university or being compliant, then I know what I'm going to choose. A good compliance program, and this is the key, and this is why the Italian authority measure rewarding companies for having a compliance program, is a measure that I think makes a lot of sense, exposes that conflict so that it ensures that somebody with a higher responsibility that is accountable for that decision, that is not conflicted because their commission does not depend on that decision, is the person that should take the decision. Compliance goes way beyond training, and it's about risk management, and it's about ensuring that there is accountability for that decision internally within a company to address that conflict. That was just to comment on your point, which I thought was a very valid point.
Ma è davvero di grande interesse e attualità, quindi approfittiamo se c'è qualche altra osservazione dal pubblico. A questo punto è veramente doveroso dare la parola al professor Marcos, che credo si sia proprio lanciato quasi oltre la frontiera dell'antitrust, però ha avuto la prudenza di mettere un punto interrogativo nel suo titolo, che è davvero challenging, che è il diritto della concorrenza deve punire i funzionari che facilitano le pratiche anticoncorrenziali. Francisco Marcos,
vediamo, grazie Michele, vediamo se riesco a vincere questa speed dating contest. Okay?
Dal titolo non so.
Prima tu mi hai guardato così atterrato, soltanto ce ne ho 4 slide e 3 idee. Allora, la mia presentazione è una domanda: deve il diritto della concorrenza punire i funzionari corrotti o non che facilitano le pratiche anticoncorrenziali? E questo viene perché abbiamo dei problemi in Spagna e non so, pensavo che forse sarebbe interessante portarli qua. Prima di tutto grazie Michele per l'invito, anche grazie professore Venacchio e complimenti per l'organizzazione. Ogni volta che veniamo qua è incredibile come riuscite a fare questo, crescere, è veramente ammirabile, complimenti. Qualche anno fa mi sembra che Michele invitava a dei giornalisti a parlare qua, questi che veniva di MLEX, no? Io farò una presentazione non molto teorica, io sono un modesto professore con questi giganti qua, Cisco, Sumitomo, Hogan Lovells, Google, allora, che non è dominante, dai. Ma non so se avete visto che c'è dominanza di Spagna sulla tavola, perché Parmigiano è sposato con una spagnola e anche Michele. Non so se Saccia anche tu hai qualche rapporto con Spagna? E poi la mia presentazione è una domanda: deve applicarsi il diritto della concorrenza ai funzionari che facilitano le pratiche anticoncorrenziali? La mia risposta è no, benché la Commissione spagnola della competenza dice un'altra cosa, no? Prima di tutto, quasi tutti ricordiamo quello che diceva Adam Smith nella ricerca sulla ricchezza delle nazioni, questo che parlava di quando i capitalisti si riuniscano sempre lo fanno per cospirare contro il mercato, ma poche volte si continua a leggere quello che dice nello stesso paragrafo, ma sebbene la legge non possa impedire alla gente dello stesso mestiere di radunarsi talvolta, essa non dovrebbe far nulla per facilitare queste riunioni e tantomeno per renderla necessaria. Allora, io vorrei guardare a una materia che forse è un po' trascurata nel diritto della concorrenza, che la radice di qualche o di tanti cartelli, almeno nell'esperienza abbiamo visto che l'origine è i poteri pubblici. Allora non è soltanto quello che fanno le ditte, ma anche i poteri pubblici. E questo è un problema trascurato, come dicono in questo paper che è stato pubblicato da Eleanor Fox e Deborah Healy nell'Antitrust Law Journal l'anno scorso, e che, secondo ho visto adesso, ha vinto l'Antitrust Writing Award quest'anno a Washington. The treatment of state acts and measures has been a neglected subject, even through excessive state restraints can be the most significant competition problem. Cosa facciamo con queste restrizioni pubbliche della competenza, right? Se guardiamo quello che è accaduto in Spagna in 2 casi l'anno scorso, questi anni recenti, ci sono stati 2 cartelli, il cartello del sherry, del vino sherry o delle uve del vino sherry, il mosto, e anche un altro cartello nel porto di Valencia. Quello interessante in tutti questi 2 casi non è una teoria grande come quello che hanno fatto quelli che mi hanno preceduto nell'uso della parola. Il ministro, il consigliere regionale di agricoltura e di industria in un altro caso era seduto nella tavola del cartello. Cosa fanno lì? Prima di tutto, secondo le informazioni disponibili, non c'è nessuna prova che ci fosse corruzione. Sono lì perché pensano che così guadagnano voti, perché sicuramente loro pensano che il suo mestiere è fare la pace nel settore, allora cosa meglio per fare la pace che fare un cartello, no? Che facciamo con questo? E una delle risposte, come vedremo dopo, è applicare il diritto della concorrenza. L'autorità spagnola ha tentato di farlo, ma non è la unica, allora è una possibile soluzione. Benché questo non è la prima volta che accade, in settori similari, le patate a Canaria, le cozze a Galizia, la carne e poi il sidro, lo stesso accadeva. Infatti il cartello del sidro era molto interessante perché il consigliere di agricoltura d'Asturias era stato così non so, impegnativo che aveva lasciato le carte con il seglio della regione per stampare l'accordo di cartella, dai, così ha più valore, no? Tradizionalmente quello che è accaduto è che l'autorità della concorrenza spagnola, quando ha guardato questi casi, ha ignorato il problema della intervenzione pubblica, benché quello metteva un altro problema, è che generava la fiducia di quelle imprese che erano seduti lì, che sì, l'autorità è seduta qua, sicuramente non ci sarà nessun problema, perché se il consigliere di agricoltura è qua, deve essere che non c'è niente illecito qua, no? La nuova soluzione che l'autorità spagnola ha usato in questi due casi, quello del porto di Valencia e quello del vino di Jerez, ha condannato all'autorità pubblica come facilitatore del cartel, alla Trojan, come ha fatto il Tribunale Generale, e secondo me questo è sbagliato, benché c'è gente che dice un'altra cosa. Infatti se vediamo Fox e Hill in questo paper che ho menzionato, ho citato prima, loro dicono chiaramente che competition law should apply to state officials who join and facilitate illegal private conspiracies. Io penso che questo sia sbagliato, e questa è la ultima slide. Secondo me l'autorità, questo è sbagliato perché, come dico qua, mi sembra che tentano di usare una herramienta sbagliata, piantare un chiodo con un cacciavite, prima di tutto perché è fuori dello scopo del diritto della concorrenza. L'intervento pubblico è probabile che questo sia deviato. Ho detto prima che non c'era nessuna prova di corruzione, ma ci sono altri strumenti. Anche qua in Italia avete questo 21 bis della legge Salva Italia che permette di attaccare questi interventi. È vero che quando parliamo dell'autorità pubblica o dei poteri pubblici seduti nel cartello, non c'è niente da impugnare, perché non c'è probabilmente un atto amministrativo, ma secondo me non è soltanto legalmente difficile, ma anche politicamente inconveniente, perché l'autorità della concorrenza non ha niente da fare con questo. Invece quello che dovrebbe accadere, e quella è la regola che si dovrebbe impiegare in questi casi, è il diritto penale e sicuramente anche il diritto della disciplina dei funzionari pubblici, che in Spagna non so se mai è stato utilizzato, perché non è possibile che questi ministri, che hanno tanti assessori, non chiedano prima di sedersi in quelle riunioni cosa faccio io qua. Allora mi sembra che l'instrumento che si usa non è adeguato, e benché adesso si parla in tutti a livello comparato in altri sistemi, sì, forse questo deve essere l'indirizzo, come diceva prima Eleanor Fox, secondo me non è sbagliato dire che il competition law deve applicarsi in questi casi. Grazie Michele.
Grazie mille Francisco. Se ci sono delle osservazioni dal pubblico su questo tema di grande frontiera, direi.
Can I ask you a question? In Italian or in English? What do you want?
Come preferisci.
Vabbè, in English then, so that people can understand probably better. I agree. I think I am not a big fan, I've never been a big fan of criminalization of companies and officials, and especially with company officers. From CFOs to CEOs, I don't think it's just not going to work for a very simple and practical reasons. These are white-collar crimes. The likelihood that these people will actually spend a day in the nick, it's incredibly low. In all likelihood, these sentences will be suspended. I actually think that the choice of inflicting sanctions that are of a different nature, like direct disqualification, are actually much more, a downside, more effective, because you cut directly the core of their own income. So I think Francisco is right. I think criminalization is exactly the wrong tool. As regards public authorities, I never given a lot of thought about that at all, because you know we've been talking about state action defense. So the only thing I will say is that this is absolutely fascinating, and that this is happening in the States, in Spain. It's pretty astounding, but I'll leave it at that. Thanks.
Aspetta, che altra osservazione dal pubblico? Antonio Creus.
But Ariana, probably it's happening not only in Spain. In Southern Europe, I believe there may be other countries with similar situations.
No, fairly quickly, though I'm fully in agreement with Paco Marcos, I think I have to nuance a little bit, because I was counsel for the harbor of Valencia, or Valencia Porto, and in fact, it's very curious, because what it was alleged to have been an agreement, it was never an agreement. It was rejected by the harbor, which was the control of the harbor, and we provided the competition authority even with a judgment, because we refused to install the control. And what it was found guilty, the harbor of Valencia, it was by object. And that's the decision for which it was fined the harbor of Valencia. The harbor of Valencia reacted to the control and to a reaction that there was a strike. There was a strike, and then the harbor of Valencia authority sat down with both parties to find a settlement. And in fact, there is not a shred of the document where there is anything likely to be a cartel. Though I agree with the others, because I know some of the other facts, this one is just to put the record straight.
Grazie mille Antonio, sono contento che siamo riusciti anche a garantire il contraddittorio a questo punto su questa questione. Alvaro Ramos vuole fare un'osservazione, prego.
Sì, c'è una domanda della responsabilità dell'amministrazione. Adesso che parliamo, qual è la responsabilità del funzionario? Facciamo la responsabilità penale. Alla fine quello che stiamo parlando è di private action. Se una società fa un cartel, è responsabile dal punto di vista patrimoniale, siamo d'accordo? E se un funzionario partecipa in un cartel, partendo dalla base che la restrizione più grande che ci sta sul mercato è quella del governo. Allora, perché l'amministrazione non può essere responsabile della condotta di questo funzionario? Dal punto di vista patrimoniale sto parlando.
Adesso vedete perché io sono un modesto professore e questo ragazzo lavora a Cisco. Ma guardate una cosa, questa donna, la ministra di Agricoltura di Andalusia, non soltanto non è stata responsabile, ma dopo ha scaduto il suo nombramento come consigliere, il mandato, è stata eletta europarlamentaria. E 5 o 6 nella lista per il Partito Socialista, no? Allora, niente responsabilità politica e neanche responsabilità dell'altra che tu chiedi. Bravo.
Bene, allora sorprendentemente abbiamo anche ridotto un po' il nostro ritardo. Vi ringrazio molto di questi 2 giorni molto intensi, di questa partecipazione fino alla fine. E siamo davvero contenti, e qui parlo di nuovo a nome anche dell'intera facoltà di Gian Antonio Benacchio e mio ovviamente, vi ringrazio ancora. In questi 2 anni che ci separano dalla prossima edizione rimaniamo in contatto con l'osservatorio, con le nostre attività, con la Summer School, e presto pubblicheremo le slide sul nostro sito tra la settimana prossima ci sarà anche il video integrale degli interventi, e a settembre ci sarà il volume degli atti. E invece alle 8:30, quindi molto più vicino, ci sarà una bella cena e avremo ovviamente piacere di vedervi lì e di continuare il dibattito in quell'occasione. Grazie ancora.
Bravo Michele, sei un gigante.
Bravi tutti.
Grazie.
Bravi, ci ha
fatto un grande piacere.